We have, once again, good morning. We have a good first module ahead of us. We're very happy to host the training hosted by EBN for the EU BIC community and our external guests in partnership with EU IPO, and we're very pleased with this partnership. We have various trainers from there, and the expert in the field will be dealing today with brand strategy for startups, domain names, IP scan, etc., but also funds. Laura will explain a bit later, CEO of EBN, what exactly the modules will deal with. And on this note, I believe I would like to give the word to Nicolas Vigneron to open the session on behalf of EU IPO.
Thank you, Brian, and good morning, everyone. So it's a real pleasure for me this morning to do this opening of this session, which is a good demonstration of the very fruitful collaborations that we have with EBN and here at EU IPO, we are very happy and proud of it. No, I would like to thank you, Brian, and also Laura Lecci, the CEO of EBN, for having come with this initiative, which is important, for us. So at EU IPO, we are the European Union agency dealing with intellectual property. So it's natural that actually we come with this training, and we are actually training you today and during these two modules on intellectual property in order to convince you that intellectual property is something important, so that in return you can also convince all the SMEs and startups you are working with of the same. So why intellectual property is so important? We do a number of studies in the European Union that demonstrates that, unfortunately, only 1 out of 10 SMEs or small and medium-sized enterprise are making use of and protecting their intellectual property assets. So there is room for improvements in Europe, and that's why we have been creating a network of and engaging in collaborations with all the people that are working very close to SMEs in order to pass the message to the SMEs. So we are also doing not only about awareness raising, and you will hear from my colleagues this morning. We also have come with a number of support initiatives, because it's not only about communicating, but it's also about supporting whenever it's needed in order to come with solutions to address the different pain points that SMEs and businesses can encounter when they are working with their intellectual property matters. So there are a number of initiatives. I would like just to mention one very key initiative that we have now we are launching for the 3rd year that my colleague Elizabeth will talk about later, which is the financial incentive to support SMEs when they go and protect their intellectual property assets. In that regard, we have already started in 21. In 22, we have improved further the scheme, and in this year, we are also enlarging it to protect not only trademarks and design, but also we are working now with the European Commission to extend it to patent and even to plant variety, which is another type of intellectual property assets that mainly used by plant breeders. So more money are available and will be made available. But also it's not only about reimbursing the different fees when you go for when SMEs go for IP protection, but also it's about providing advice. And for that, we are very happy to count on Mary expertise there, who is one of the experts providing IP scan services in Europe, and this service is something that we have been growing. The community has been growing, and we think and we are convinced with the European Commission that's a very powerful tool for supporting businesses. You might say, yeah, but we are the innovation community. So SMEs, we are not only dealing with SMEs, but about startups. When we looked at the figures from this year, already more than 7,000 small and medium-sized enterprise have requested access to this financial support, which is a very huge number compared to last year, where we had already a good start, but we overall only reached out to 22,000 SMEs, and 48% of these SMEs are actually startups. No, just to demonstrate that how it's important to reach out to the innovation community, and actually the tool is a useful tool. That said, I would like just to wish you a very good and fruitful training this morning. I hope that you will learn a lot, that you will dare to ask all the questions you have, and because these experts are there to answer all your questions. And once again, I would like to thank you very much for your attention and for the excellent collaboration we have had with EBN. Thank you.
Wonderful. Thank you, Nicola, for those opening words. I'm passing on to Laura Recci, CEO of EBN, to tell you a bit more about the training and about EBN as well.
Good morning, everybody. Good morning, Nicola. A warm welcome also from my side. As briefly mentioned at the beginning, we are particularly delighted at EBN to really kick off our EU-BIC training track with this one, with such a strategic partner as UIPO. Also considering that the main target, let's say, the main client companies of our EU-BIC communities, and I will tell you in a moment who that is, are extremely innovative companies. So IP is such a crucial element that needs to be protected, reinforced. But also here today, and also the 30th of March, you will hear also how that can be actually, should be considered as a business asset. So thank you very much again to the colleague from UIPO for counting on us and involving us in such great initiative. I do recognize many names from the community, and I'm very proud that they jumped on this training, but I also see some external guests. So let me just give you very briefly what EBN is and this EU-BIC community is composed of. EBN is the network of business support organizations such as incubator, accelerator, development agency, all those business intermediaries whose daily job is really to support the creation and the growth of successful innovative companies. At the moment, EBN and EBN members are operating in more than 35 countries, really trying to thrive innovation and entrepreneurship all over Europe and beyond. And what is probably most interesting also to hear is that behind the organizations that do make our community, that we can count on the expertise on more than 600 individuals that really spend their days with innovative entrepreneurs, with startups or more mature SMEs that are willing to take sort of an innovation journey. And only last year, our members did support more than 36,000 innovative companies. What is probably peculiar of EBN is an association that has been operating now for almost 40 years. And since the beginning, together with the European Commission, we have conceived and developed the EU-BIC label as a sort of a special certification where we look, we evaluate, and we monitor on a yearly basis the quality of the services that all these organizations that I mentioned before do deliver for the entrepreneurs in order to make an impact for the regional economic sustainable development. So we do grant, and at the moment we are the only one that can grant this EU-BIC certification, and everything that we do is also to try to support those organizations to improve continuously their services. And how do we do that? Either with training activities such as the one of today, and we are actually kicking off these year activities with the training on IP. but also giving to our members access to best practice that either come from the community, but also are external and can bring relevant expertise. By organizing meeting, by connecting them each other, facilitating their encounter per, an example, different topic, different sectors. We do support this organization to get together in a collaborative international project, as we put at the disposal of a younger organization or younger innovation ecosystem with our technical assistance, basically transferring the expertise that we do have at the Secretariat and we do have in the community, thanks to our member, to help other organizations, other ecosystem to get organized and to really try to make an impact in the creation and the support of innovative companies. And then, of course, we do count, in order to do that, we do count on few strategic partners. We have mentioned already EIPO, the European Commission in general, and a few other agencies, but also corporate investors, depending very much on the needs that our members scout in terms of for their entrepreneurs and in the companies that they support. So, as I was saying, one of the activities that we do have in order to help our EU-BIC and associate member is the EU-BIC training tracks. It's our corporate knowledge building activity, several specialized training courses that really are dedicated to the business intermediaries, the EU-BIC community, innovation professionals, with the main aim really to improve their services, to improve their operation towards the entrepreneurs that they support. And so usually the EU-BIC training tracks cover many topics that they do always relate to the day-to-day job of business support organization, being the operation of an incubator or tools to assess the readiness of the company to go international, information on specific international markets, but also we did cover in the past access to finance, and today specifically the focus on IP, understanding, protecting, commercialize, and enforce innovation through IP. The EU-BIC IP training track is made of 4 key learning modules distributed on 2 mornings, today and the 30th of March. And we really wanted, together with the EUIPO colleagues, really to cover the key elements, the key learning elements that should help business experts to better support the entrepreneurs when it comes on this specific method, to make them gaining concrete understanding on the methodologies and the services that are available for entrepreneurs, startups, and SMEs, helping them to scan, to file, and protect innovative ideas or brands and invention through IP. Thanks to the expert that comes from EUIPO, you will also gain access practical tools and best practice on how to utilize the services that are available there from EUIPO and the European institution to enhance the support to your support to the startup in the growth journey, and hopefully also, which is also the format that we try to use, is also to try to transform technical knowledge into really practical hands-on advice that you will get thanks to the experts. So again, a warm invitation from my side. Please do contribute to the conversation. Do not hesitate to address your question because really you do have the expert in this virtual room. what's on the menu for today? We will probably focus, let's say we start from the basis, right? So the first module is about business planning and IP. And now IP is so important that needs to be an integral part of the business strategy of a young startup. And now IP can be considered a business asset. The second module, so the second part of today's module, while we'll give you sort of the broad opportunity when it comes to understanding trademark and design registers, but also a very interesting focus on the funding tool briefly mentioned already by Nicola, so that you understand also the wide range of opportunities that are there for the companies that you support. So without any further ado, I give the floor back to my colleague Bram Powell so that he can introduce you the great speakers that we have the chance to have with us today. And thanks again for joining us for today's training.
Thank you, Laura. Thank you, Nicola. Well, once again, welcome to the training. And again, feel free to keep your camera open. I see a lot of faces, familiar faces and new faces as well, all over the world, from Lebanon to Egypt to Alicante to Brussels. Good to see you. This is your training cohort, so get used to each other. We'll hopefully see each other the 30th again in the second module. Don't be strangers. On this note, I saw him sliding in the screen already. Philip, oh man. Would you enlighten us on brand strategy for startups, trademark filing, and NDAs?
Yes, sure. Hi, good morning, everyone. Also from my side, I'm Philip from the EU IPO. I'm currently working here at the opposition division. I was previously working for a couple of years in private practice, and I'm very happy to see all of you today to take the training opportunity. It's a big pleasure and honor for me to present these topics. I hope you can hear me loud and clear, see the screen I'm gonna share with you. And my presentation today will be about branding strategy, trademark and design filings, and NDAs. So as most of you will probably be aware, these 4 topics are probably enough to fill an entire day of training. So what we will see today is a bit just of a warm up and an inspiration for all of you to get a general overview of different aspects that are important for you during the training, during the business planning. I will touch first branding strategies. What is a brand? Why? What does it consist of? What is its function? What can I do to develop a brand? And then we will look into tools that are part of the branding strategy, particularly trademark and design filings. And then in the end, we will look at non-disclosure agreements, which are an essential part also of your IP strategy. What information should I keep confidential? What is confidential information, and how should I treat it in contracts? So we start with a brand strategy. Now we have a quick question to the nice logos you invented. I took a dummy, an avatar from our last green trademarks study, which is available on the Observatory website. The EU IPO investigated, so to say, in the field of the renewable technologies or renewable energies and green technologies. What is the impact of brands? So I invite you also to look always a bit through the website of the EU IPO, through our studies. Nicola also mentioned some of them before on the use of IP by startups. And so here we have the green man, so to say, or the green avatar holding a leaf, which is a bit holding on his hand the IP, which is the business asset you are creating with your companies, and which can help you to gain a competitive advantage in the market. I quickly start the timer so I do not run too late later on with the presentation. So what is the function of a brand? It's a bit a vague term for many of us, but there are definitions of it, and they say it is to establish the distinctive identity of your company or of your entity in the market. So this is really already the presence in the market when your startup company was founded, when your initial idea was proven successful, and you put a first foot into the market. So this is really the place where all of you want to go, where we want to see you. You are in the market. So you have a product developed, services developed, and the function now is of the brand is now to make your products visible to the customers and stakeholders. So it identifies your goods and services or your entity from what makes it different from another company. So in the field of, you have competitors, and you want to, of course, to stand out of there, and what makes you different from the others. This is what the brand identifies, and the function also of the brand, and it's an important driver then for you to show who you are. And your brand is a marketing related asset, and it consists of names, terms, signs, symbols, logos, and designs. So we will later on touch on the domain names, which is part of the brand identity. We will go into detail on signs, symbols, and logos and designs as part of IP rights, trademark and design filings. And yeah, the idea of all these tools and assets is to create a distinctive image that makes you coming into the mind of your stakeholders, your potential customers, and that in the end contribute by doing so to create economic benefits and values of your company. So brand is really an important asset for you, as important probably as your investigation, your research and development efforts, because once you research and develop and have a product, then the question is, how do I get it into the market and make it successful in the market? We have different stages in this respect. First of all, you need to create a brand strategy. What can I do to leverage the brand identity as a financial asset really in the market to achieve my business results and objectives? For that, I have to develop a brand strategy. I have several input factors that are coming from your side. What is the quality of my service? What are my real assets? What is my innovation? So you have to develop a bit the essence of your product. What does it bring for the customer? And the next stage, once you have developed a brand strategy and put it into, so to say, the market, the next question would be how strong is my brand in terms of return on investment? How legally protected is it? Can I enforce it against others? That is the brand strength, which is all an important driver for brand strategy. And then how does my brand actually perform? How can I support my brand performance in the market? And the last strategic driver is then, what is actually the value of my brand? How can I evaluate it in terms of money? Because once I have a valuable brand, it grants me access to finance. It grants me, it secures, so to say, income to develop new products, and this is all intrinsically linked to the brand and the value of the brand. And these are, so to say, 5 strategic drivers that you can always may always want to include directly from the outset into your business planning. The next slide, this is also already the last one, also on brand strategy, is how to plan and build a brand strategy. So first, it needs to be so to say aligned to what you do in terms of your business strategy and how you develop your product. So you have to be creative and systematic. You have to appeal to your customers' emotions and reasons, and reflect deeply really what are your business objectives, who do you want to reach, where do you want to reach out, and this can be all included in the usual business planning cycle. So I included here a typical image, so to say, of what business planning involves, and it all factors of these planning steps, you can include, or should include, probably the brand strategy as one potential topic. For example, if you analyze the market, look out for your competitors. In which market do you enter? What are the strategies of your competitors? How do they try to create the distinctive function of their product in the market? Be aware of risks and possibilities. And then some typical steps to build up a brand is to define clearly in a business plan, ideally as soon as possible, or at least to start thinking about it. What is your brand's mission? Who would you want to reach? What is the purpose and the philosophy of your brand? What is your vision? What are your goals? For what will your brand stand in the market? What makes you distinct really from the competition? And then identify what are your brand values. What are the fundamentals behind it? Is it technology? Is it an innovative service? Is it it really depends on the industry or the market you are entering. And then develop, so to say, your brand's voice. How do you communicate? Which means of communication do you take? You use social media. What values do you want to transmit on your website? And what personality actually is your company or brand representing in the world? And then the design of a brand's identity. Here we will touch on a bit later. You can use soft IP rights. The soft IP is a bit of internal expression in contrast to hard IP, which would be patents. Soft IP are designs, trademarks, domain names. So to generate the look and feel of your brand in the market, you can and registered rights are the best mean probably to protect that look and feel against competitors or others who want to infringe you, or want to copy you, or may do it without intention. Yeah, and this is also something you probably already saw somewhere on a company brand guidelines. So you really in your within your team and your company, you set instructions, parameters, and standards on how to appear on the market, how to be present on the market, and these are normally set out in a set of guidelines, brand guidelines, where you define, we use, for example, here we have the EBN or the EU IPO logo, where we say, we use this type of logo for this occasion. We use the logo version for the app icon without verbal elements. And all these parameters can be set out in the brand guidelines, just to make it clear that you have a consistent image in the market, that all, so to say, fonts on the website are the same, and this should be so to say agreed on by you, by the leadership of the company, together with your marketing knowledge, or even external advisors, to develop a bit the brand guidelines, which is, I think, a very good and helpful tool when you step into the market, because you can always review it if you see you do not reach the results, but like this you have a unique appearance in the market. Yeah, and the suggestion I would have that it always should be the brand in alignment with your overall business strategy. Go into the market, what do you want to reach there, and adapt your brand to that goal. Good. So this was the part on brands. If you have any questions, please put them in the chat. I will rush through the slides. I hope it's not too quick, but then like this in the end, we have maybe a bit more of time to discuss open questions. Now I want to tell you some more about trademark and designs. Let's see what the response of our EBN colleague is. Yeah, they say that the design is the appearance of your product. So the appearance, the shape, the outline, and the trademark tells your customers who you are. These are typical logo symbols and trade names. I will start with the trademark and trademark filing, and define your strategy. What is an important driver here is, of course, the relevant territory for you. Which are the geographic markets you want to enter? where you want to, or where you should protect your science to have it, so to say, the monopoly on the name, and to have an effective tool to prevent others from using it. Strategic drivers for defining a strategy are the awareness first, that what are the risks of IP of others. Mary will probably discuss this a bit later on. We have, so to say, we have to be aware that others are already on the market with their brands, and the IP strategy, this is what we always recommend, is that it should be adopted or endorsed by the leadership of the company. So it must be really a top level priority, because it is important to protect your assets in the market. And therefore, first of all, my point is, okay, make yourself aware. Today we have a webinar on this, just because to increase the awareness, maybe the knowledge, or to profound it a bit. And this is like a continuous circle. So once you are aware, you go into further details and look into the related risks to it. Then another next important driver is the generation of the IP, where you have to establish processes during your business planning, how to file, how to administer, how to document certain filings, this filing strategy, how to go, so to say, to the registers, which countries, and then at what point in time. And once you are filed and in the market, you should look at how to enforce, how to defend my trademarks and designs. I have to monitor the market. If I see newcomers coming up with or other companies coming up with similar brand names or copies of my designs, then I have to consider if this is infringement, if it is an infringement of my rights, if I should take action, how to take action. And this is also advisable to have this defined in an overall IP strategy, because it does not always make sense to go against every infringement, because many of them are maybe not intentionally and done to copy you, but just because the brand space or the IP is so important for everyone that others come up with a similar idea, and maybe they are just not aware of you already being on the market. Yeah, and then in the end, where it becomes really interesting for you are IP transactions. So you are a successful company in the market. You want to go into new markets from, for example, Germany to Egypt or Lebanon, but you cannot build up your own distribution system there. So you need to rely on locals, and you can license out then the IP. And also licensing in might be sometimes necessary if you want to use other people's licenses. This particularly in the field of patents, more maybe than trademark and designs. If you have standard essential patents in your product, you have to manage, so to say, incoming licenses, outgoing licenses, and then also make sure that the payments are done and that you receive money back from your IP, which then of course helps you to develop further your brand strategy, to go into new products, and also to look for just a return on investment. And this can be, the IP performance can be measured, analyzed, and evaluated. And again, this should be done, so to say, in a cyclical way, whenever you maybe once a year, or even more often, whenever you have, so to say, an audit of your processes, include IP and your drivers in the assessment. Yeah. And then again, okay, we have different kind of innovation readiness levels at your company, and your IP strategy should always be, so to say, aligned to your level of readiness. If I go to the market, then you are already very advanced, but even in an early stage, when the idea is coming up, you can already look, Mary will tell us about this, for third-party trademarks. You can look for the, so to say, the prior art in the market, and then amend and adapt your strategy at early stage if necessary. Yeah, and here I wanted to give you a couple of examples of what trademarks can be, and which types of trademarks exist, at least for the time being, in the EU and the EU member states. Many of them are also available in other countries, some others probably not. So what do you expect when I press now the next button? These are, oh, the sound should be off, but okay, I will just speak a bit louder. So we have multimedia marks here at the EU IPO registered. So these are, let's quickly see how I can get this silenced out, or we'll just click. And you always have to look, can I get the mark registered? Is it descriptive or is it non-distinctive? Oh, I will stop these. No, I will just silence them, so like this. And here on the left hand, you see a couple of marks which have been registered as a multimedia mark, which is available since 2016. So you can file sequences of images, sounds, videos together with sounds. And on the right side, we have an example of a trademark which was refused by the EU IPO because I think it was filed for retail services or monetary affairs, and we just see the euro, different euro indications, and this is not considered to be capable of distinguishing your products from those of other companies. So this is something that you can always include into your assessment of your branding strategy, of your IP filing strategy. Can I protect what I want to use? Is it necessary to protect, or is it available for all? And then we have these different kinds of usual trademarks, word marks, figurative marks, logos, shape marks, and then also more fanciful ones like pattern marks, motion marks, sound marks, multimedia marks, and these last categories, they are increasingly important in the digital economy where brands or trademarks are used more and more online. So you do not only look on a physical product and on the label on it, but also on where you promote and market your products online. And this is one example for a concrete trademark. What is a trademark usually consisting of? It is a sign. We just saw this. There are different signs available, and I included here the different risk and or drivers in the table. So you have the sign first of all. Here we have a no, the video is not going on. Naja, it will. But what you have to include in your business planning is the timeline. The trademarks usually take a time before they are registered because it's a formal registration process. The registration process consists of different phases. So first of all, the trademarks are examined. Is it distinctive? Is it not distinctive? Are the goods and services clearly defined? And then in most countries, you have a period of several months where third parties can oppose to your trademark if they believe they have earlier rights. And this is so the timing should be ideally in your mind, in your business planning, because you should always file your trademark before launching the product and also clear the market before launching the product, because once you launch a product and with a brand or with a trademark on it, third parties can come and say, oh, you're infringing me, and then you have to turn out the benefits. And one next to the type of trademark you're choosing, you have to look into the relevant classes. We have international classification system where every product is classified into up to 45 classes. In this case, the trademark was filed for computer interfaces and advisory services in relation to IT, which is a very common class, I think, for probably most of viewers, everybody who's doing digital business, but also digitalization of more traditional industries. They are more and more increasingly going into class 9 and 42. And this leads to some sort of a cluttering and also of an increased risk in these classes if you file, because almost every company is going into class 9 and 42. These are called, so to say, versatile classes because they are relevant for all types of industries. And this means that the potential to conflict with other earlier trademarks is higher a bit, maybe in classes 9 and 42, just because there are so many products covered. So we have all kind of technical apparatus in class 9. We have software in class 9, and we also have like information technology devices in class 9. And this usually leads to an increased amount of proceedings or positions. Most of these, or many of these, can then be resolved amicably, but it's another point where you should be aware of. So the trademark, the type of trademark, the goods and services, and then last but not least, the territory. So you should cover the relevant markets where you want to go with your trademarks. It can, and the timeline can change or vary very, very significantly from one market to the other. We have China, for example, where it's very difficult to get a trademark into the market. The examination in the EU differs from the timeline in the US, and this is why it is usually advisable to go into the trademark filings as early as possible, and just to have enough time to get the mark registered before starting business. And this is a bit the slogan for it. So yeah, filing strategy can lead into a dead end or onto a fast lane, and this depends a bit on your strategy before it. You can contact third parties which have similar rights, ask for consent, or if you don't be aware of other rights, it can mean that your trademark that you have created will simply get lost and you cannot use it because of another party in the market, maybe even for a different product, but still within the range of similarity can block you from using it. So that's why we will talk later on availability searches with Mary, and this is a standard essential step, so to say, for you before going into the market. Check if the trademark is free. It's comparable to a freedom to operate search for patents. And now we move to designs. We have two classes of designs. We have the registered designs and unregistered designs. The designs, they do not protect the name or the or different shapes or logos, but the appearance of the product. So really, when you look around now on your table and you see whatever device you have in front of you or the screen of the TV behind you, or whatever it is, it's the shape, the look and feel of the item you have around you. So any industrial or handcraft item can be protected or is protected even by, automatically by design law. You can protect, or the lines, the contours, colors, shapes, texture of the products or materials are under the design protection, and it can also include parts of complex products. So the packaging, the getup, or even the graphic symbols or typefaces on your website if they are created. So here I found, for example, some nice slides on the EBN website on a typical graphic symbol or a graphic configuration that could be registered as a design. And now the main difference here, or the main point where you should be aware of, unregistered designs are valid for 3 years only. So what are unregistered designs? You launch a new product, you make it public, and then for the term of 3 years, even without registering it, you join some protection for it. But the protection for unregistered designs is really limited to imitation. So it must be more or less an exact copy of your product. And the term of protection is limited to 3 years. So if you have a longer lasting product that is in the market for more than 3 years, it is always advisable to consider a design filing to register the design. The protected design, the design protection then can last for up to 25 years. It is a design can be renewed here at the EU APO. Maybe the national other jurisdictions might have other renewal terms, but here we can protect up to 25 years in 5-year steps. And this is particularly relevant for longer lasting products. So not what fashion industry, for example, where you change the shirt design every 3 years. Maybe unregistered designs are a suitable means and enough. But if you have something that is in the market for longer, you can register it. Also, always with a view to maybe license it out, the design, because the design is not limited to a certain product, but the design can also be used if you have a machine and then you want to use it on toys. You are different to trademarks. You do not have to file for a separate trademark for toys, which would be a different class to a machine, but it's simply the design as it is registered for and protects the appearance of the product as it is, irrespective if the product now is fully functional or not. And one very nice feature of registering designs, as we are talking later on non-disclosure, is that the publication, the actual disclosure of the design, can be deferred for more than 2 years from the filing date. So if you have a prototype developed and share it with your incubator, or you just don't want to make it public for the entire world, you can request that the actual representation of the design is not made public, but you will have the filing date assigned. For example, it will be filed today, and until 2025, end of 2025, the actual design itself will not be made public to the market. Yeah, and this is a bit from our website. Design is actually everywhere, really, where you look around. Anything that is touched by human hand is a design, and design protection is much easier to get than a trademark. There are not so many checks, and this means that a design is actually registered within, I think we are now at 10 days here at the EU IPO. So you file a design today, and in 10 days you already have the registration at hand. In the following slide, I wanted to give you a short outlook on some examples of a design. Important to note is also that you do not have to have just one look, but you can really take different views of the product you have. Here I looked into our design database for space vehicles, and then you can see, oh, this product is so to say a flying car with wings spreading out, and you can protect the different functions a bit of the features of the product itself. So with the wings spread, with the boot being open, and this is for every product category, so to say, has a different class, and you can look this up in your business planning. What is on the market? You can look for companies and simply type in the company name, or you can look for the product indication. And here, if you type in air vehicles or space vehicles, you will find, for example, this. Then we have graphic user interfaces, which are important for or useful to protect, so to say, the features of a software application. For example, we always have the issue software itself is protected by copyright, which cannot be registered, but the way how the outcomes of the software are presented is suitable for design registration. So your graphic user interface of your application, or even of the controlling devices, and how the information is displayed, this is open for designs. Designs have one limitation: they must be new and possess individual character. We at the EU IPO, we do not make an exhaustive a check if there are comparable designs on the market. So this is really up to the businesses to check if their appearance of the product they register is really new, or if there is something in the market that creates the same or highly similar overall impression. Then you would have your registered design would be open for cancellation. As trademarks, designs also operate on a first come first served basis. So there's really no point in delaying a design registration. As soon as you have a design created, a product, a prototype, you can file it together maybe with a deferment. Important is after you make a design public in the market. For example, this car is not yet on the market as far as I know, but if it is made available within 1 year, you have a 1 year grace period where you can still seek design protection. After that 1 year, your design will not be considered to be new, because your product that you self-disclosed would destroy the novelty, the the character to be new, and therefore your design could be simply cancelled on the basis of your own product in the market. And the term of the unregistered design of this car, so imagine I would start selling it tomorrow without design registration, it would only have a 3 years term of protection. And then after 3 years, everybody else could essentially do the same product, even if they don't have the underlying technology. And if you want to protect this particular product and its shape and its features for longer, for up to 25 years, it's advisable to register it on time. Yeah. So the micro recommendation will protect your designs, the appearance of your products. And before doing so, be aware, look a bit what the market is done, what is the prior art, and also with a view to look which products or which views you should and can protect. Let's have now I have a case study prepared from a German company, Orkan Energy. I don't know if anybody of you knows that one. They created organic Rankine cycle energy technology, so they can convert unused waste heat in almost every industrial power plant where heat is generated as an output. They invented a technology to convert this heat, this leftover heat, into electricity that then can be fed into the grid or used by the power plant itself. The company went into operation in 2009, and it started at the Technical University of Munich. And were founded in 2008. And here on the first screen, you already see we have a trademark on the upper left hand, Orkan, the efficiency company. Then we have a company name, which is part of your brand, the intangible asset, the marketing related asset. How do I appear? How do I act in the market? And they have their website protected. In terms of brand development or strategy, it's also a nice play on words. I don't know if anybody of you speaks German, but the Orkan, this is the German word for hurricane. So it is written usually with a K. So here they have a play on word on the organic ranking cycle, which is abbreviated as ORC, and then they just added a letter A and N to it, and they have a speaking mark, so to say, which is sufficiently distinctive and somehow significant for strength and for power, because it alludes, at least in Germany, to a hurricane. And yeah, what do I have now? This went a bit quickly, but they have several patents, patent families, actually 3, filed since 2009. Here you can see a bit, which is always an important driver also for you for filings, ownership, who should be the owner of your IP rights, which company is it. And here we had a different owners, the AG, which would be a stock company. Then we have a limited liability company and the Technical University of Munich. So ownership, co-ownership is always an interesting question for you also to include in the business planning. Here they filed in 2009, they filed the first trademark, again here in class 9. 7, 11, and 42, I'm sorry, for machines, machine tools, and appliances, electronic appliances, and 42 again for innovation. So shortly after they founded the company, they directly filed a German trademark. Then later on, they expanded the German trademark to the European Union. They got new sub-brands, Efficiency Inside. Here we see an example from the UK IPO. So they also considered doing business in the UK and expanded into different territories. Then here we see some examples for trademarks that had been rejected. Efficiency Pack, because the technology is they were refused by us, the EU IPO, and also by other countries. I think because efficiency experts and efficiency pack is descriptive of what they actually offering. So their technology provides efficiency in a pack, and this means that this trademark for those type of goods cannot be protected. What they did not do, they did not seek protection for the letter E standalone, which might be an option when you see, oh, I get into a registration can become difficult. I go only to parts of it. So they have a rather developed trademark portfolio of filed and registered trademarks throughout various classes and in various territories. So here in this overview, you can see what is a word mark, what are the trademarks, and all the different countries here marked in different shades of blue are, so to say, protected. We see they do not have protection in many countries of Africa and Southeast Asia, and in Latin America they lack protection. But whenever they consider doing business in those countries and provide their solutions in those countries, they will usually also expand their trademark protection into those territories. And now if we look into the designs, we have to look, are they sufficiently protected as well? This is, so to say, the final product as it comes to the market. So these containers, they are plugged into or next to the power plant and so to say generate additional energy with the heat. Here's another generation of these converters with the logos and the brands on it. And you see, for example, on both products, you can see different edges and shapes, and which would be suitable for design protection. And also this product development or latest development, I think, is from 2019. I saw on the website, and if it's not registered 2019, the unregistered design is lapsed last year. So and if we look at their design portfolio, they only actually protected one design, which is, so to say, the inner life of their company's main product, the converter itself, but the entire look and feel was not protected by designs. And here we have to be aware again that the unregistered designs are only valid for 3 years. And my recommendation would be then always to, I think this is now in the summary. So we see that the trademark is protected for all the relevant goods and services as a check. We have the designs, consider design filings for every new generation of product you have, and not only the first one. So here the 3 product configurations on the right hand, they could all be perfectly registered as a community design for up to 25 years. Now they are not. So this means they cannot be, the unregistered designs lapsed. So this is a bit unfortunate. Maybe it's not a major issue, but you have to define this in your IP strategy along your business planning. Which importance do you give to the IP or not? One study we have published recently was conducting a study on how companies, and particularly SMEs, perform if they create IP right bundles. So they have patents together with trademark and designs, and the outcome of this was that the turnovers of companies that have actually IPR bundles perform better, have more turnover than those that only use one form of IP. And this would be could be a driver for your strategy. Whenever I can, I use patents, trademarks, and designs simultaneously, and I evaluate and monitor these during the entire business planning and product development cycle. So far I think to the trademark and designs, and now the last 4 or 5 minutes I would like to dedicate now to the protection of confidential information. Know-how and confidential information is considered to be the currency of the knowledge economy, according to the Trade Secrets Directive, and it is because we have production methods and all kind of confidential information and know-how which is not disclosed in the market, which cannot be protected, maybe because the innovative staff is not high enough, but still it provides you a competitive advantage in the market. And this can be protected in your business-to-business interactions with non-disclosure agreements. On the next slide, I wanted to show you some slides on, or some statements on what our non-disclosure agreements actually are. They are contracts between parties and through which valuable information is kept safe. So types of confidential information are ideas, know-how, description of inventions, chemical formulas. Coca-Cola, I think the formula is a very important confidential information and trade secrets, your research results, but also business information and negotiations, who you are contacting in terms of financing, who are you contacting in terms of cooperation strategies. All this is confidential information that can and should and maybe worthwhile to protect by way of NDAs, non-disclosure agreements. And the common characteristic is that the information, the confidential information, has a value for the party that is disclosing and needs to be kept secret to keep it valuable for the company. And we distinguish usually between two different types of non-disclosure agreements: unilateral disclosure of information and bilateral disclosure. Bilateral disclosure would be, in a typical example for that would be a joint research and development efforts, where both parties bring in confidential information with a view to reach the next step of a new product generation, whilst unilateral disclosure would be rather applicable to vis-a-vis banks or financiers, where only the party seeking finance is disclosing its information, saying to the bank, okay, this is confidential information, you have to keep it confidential, whilst the bank has no such confidential information to share with the company. And in this case, the clause would be unilateral, while a bilateral. And typical clauses in NDAs is that you should clearly define what is considered to be confidential information. So what really makes it worthwhile to keep it secret. You can list it, it's usually listed, and it should be listed in the contract. So you say, oh, this prototype, its shape, these business papers, all this is confidential information. Then another typical clause is that the use of the information must be limited to a specific purpose. So for the purpose of collaborating and for developing the new product generation, we hereby share this information, and the information should not be used for any other purpose. Then also limitations on the disclosure of the information. This relates to the parties at the recipient of the information who can actually see it. So the employees of a bank who should actually have access to the information disclosed by a company. Here we usually talk about a strictly need to know basis. So only persons who need to know and need to have access to the information should be allowed to see it, and not just everyone in the company, because the outcome would be that it could be disclosed without you wanting this. Then you can also quickly define what information should not be covered by the confidentiality clause. You have to define the term, how long this obligation should be binding on the parties. And finally, it's always a question which law and jurisdiction which should be applicable in case of a dispute. Now I'm going to the last slide, because limitations and risks, non-conventional agreements, they have certain limitations. They are only contractual obligations, so they must be enforced in private litigation. They are not enforced ex officio. There's no official authority looking if usually the confidentiality clauses are observed or not. And therefore, it's always really good to ask yourself, do I really need to share the information to reach the goal that you are aiming at with this sharing of information? And we can also think about not only signing the NDAs, but also take additional security measures, such as physical restrictions, lock the documents in a safe, or put them into a bank account, or maintain a logbook, who has accessed the information at what time. These are physical restrictions. Then you have digital restrictions, use of passwords, blocking use of USB drives where the information is stored. Again, on a strictly need to know basis, that people only within your organization, or more importantly, maybe even outside, how do they access the information that you are sharing with them? And then you have some sort of supplemental protection by way of the trade secret directive here in the European Union, or the respective trade secret laws. So this is a different body of rules. So this is not a private contract. This is ex officio protection, so to say, but the shortcoming of the trade secrets is so to say that there is a public enforcement, but the result of the enforcement would not be that you get damages in case of a disclosure. It would be just a fine, yeah? But your actually commercial loss, so to say, will not be directly covered under the trade secret. And then one important thing under the trade secret, so directive, it does not forbid reverse engineering. So if you have a technical result and somebody comes to the same outcome by way of reverse engineering, that would be not an infringement of a trade secret, whilst you could forbid reverse engineering explicitly in your non-disclosure agreement. So it's also you strategically protect and manage your confidential information along the value chain. This would be again our advice. Look what and when to share and on which confidentiality basis, and plan. And the best way to protect confidential information is always to not to disclose it at all. And if I disclose, only on a need to know basis and as to the most limited extent possible. And these were, so to say, my slides for non-disclosure agreements. I have a last slide and want to for questions and answers, for summary and outlook. What is on the horizon and in the pipeline in the IP world? We have of course your annual conference coming up of the EBN, which is an important milestone in during the next months. And I would like to, if you like the presentation and the IP field, that you maybe use also your conference or your business gatherings to discuss IP strategies, to see if there are doubts. Then for branding, we have startup events, global startup awards, where it's worthwhile looking what are other companies doing to see a bit the market analysis. So there will be there are several organizations organizing these startups. And then one very important development in the IP world will be the entry into force of the unitary patent court system. And I think in June it starts, where you can find additional information on the website of the European Patent Office in Munich, because it will the aim is to create a better patent system for Europe, which is cheaper, more affordable than the current system, because we have right now a patent system where each patent must be, so to say, validated or registered on a national level and then validated on a subsequent basis in additional levels, additional countries. And the new system will, so to say, allow to make this more cost efficiently. And also in the field of designs, registered designs, we have a legislative package from the European Commission looking at the current directive and the regulation on European Union designs and national designs, which will make design registration quicker, cheaper, and more predictable. And my personal speed reading of that was a bit of all these two initiatives together was that the cost savings that come in to play with the new patent system provide, so to say, companies with additional financial buffer to that they can invest for design filings, trademark filings. So with the same amount of money you would have to spend today just to protect your design on an EU level, as of June, you can probably also get for the same price the designs and trademarks included. Yeah, and this is, so to say, the end of the first session. I hope you learned a bit. You see a bit the importance of trademark and designs, how that you got some inspirations of how you can adapt this into your brand strategy, how you can adapt this, implement this into your business planning circles. And yeah, you can always contact me as well. Let me quickly see. I think I put in my email address here. I had help of a young professional here at the EUIP with the slides. And yeah, I wanted to thank you very much for your attention. Wish you all the best and good luck with your endeavors. And if you have any questions, I did not look into the chat. Please feel free to put them forward now.
Thank you so much, Philip. Insightful presentation for sure, indeed, going from brand to business strategy, IP strategy. Also interesting to slightly tip on the Google patents, which you showed. I think that makes a link potentially with the IP scan, not per se using Google patents, but I'm for sure it will be a red thread throughout the whole training. We'll also come back to it in the second module, where we'll be looking at if there are more options for an SME than building a product to start a company. And there we will see how you can innovatively combine patents to come up with new business ideas and actually companies as well. I do believe, and I have to thank Mary because she did a stellar job in the chat. Thank you so much for answering a lot of questions. Perhaps while our next speaker is getting ready, Agneta, feel free to start up your presentation if you want, Agneta, and open your camera. I will open up the floor to the participants. Are there any further questions? And feel free just to open your mic and jump in. I'm sure we can organize this in a normal fashion.
I'm glad to present you on the topic which most probably doesn't sound obvious to you, as a connection between a domain name and a trademark is not so straightforward nor clear, I believe, at the first glance. And my guess is also that a topic of a domain name as such is not so exactly clear to you. So what I would do, I will start with a domain name, speaking about the domain name, and then I will connect it properly to a trademark so you can get a whole picture and understand the interconnection between the two. So what is a domain name? A domain name is just an online address that allows you to find a website over the internet, right? You're just typing into a browser some email address, let's say, not email address, but the website address. Let's say it is surprisingly www.ebn.eu. And the part before the dot here in the green circle is just called the professional jargon a domain name. Actually, it is an address, right? So we call it a domain name. And this is after a dot and before a dot, sorry, and after the dot is .eu, which is a so-called extension. And you might have, of course, different extensions, for example, .com, which is the oldest extension over the internet. Then you have so-called country code extensions like, for example, .de for Germany, .be for Belgium, then functional extensions, .net, .org, etc., etc. And we, URIT, we are the company I'm representing. We are the registry appointed by the European Commission to manage all domain names with .eu extension. And so in short, .eu is the European extension for EU citizens and residents. And the purpose of introducing .eu address back in 2006 by the European Commission was to create a safe online space to support the European digital single market, and the market which is to be safe, preferably, predictable, and somehow reasonably regulated for the common good of all the Europeans. And since URIS was appointed to be the registry of the .eu domain names, from the very beginning, I would say that our vision was to ensure the highest safety standards and state-of-the-art technical solutions for .eu online environment. And for that sake, for the sake of our, I would say now short presentation, I would just focus here on some direct brand protection tool, which we are providing for .eu domain name users. And probably at this point, you are already wondering what is the connection between such a technical term as a digital address, which serves purely for the logistics, right, over the internet, to European trademarks. So let's focus a little bit and have a closer look at that. So when we look at domain names versus trademarks, what we for sure know is that trademarks existed before the internet. Yeah. Then that one can have a website with a website address, because one cannot exist without another. but no trademark. Then somebody may have a trademark, but no website. That was usual in past, right? Currently, probably everybody is online. Everybody has trademark or is online. So, but in general, it's possible to have trademark and no website. And then that registration of a trademark and of a domain name are just two separate procedures. So by now, we don't see any clear connection between domain names and trademarks, right? So maybe let's try to look into numbers and specifically into numbers related to .eu domain names versus European trademarks. And you can see that in 2010, there were about 98,000 new applications for European trademark. And 10 years later, there were 177,000 applications. And at average, 135 new European trademarks are registered each year. And then at the same time, each day at average, there are about 130 new EU domain names registered that are identical in name to the European trademark name. So in summary, we can say or notice that in 2022, there were over 48,000 of .eu names registered and being identical with the name of a trademark name. And that doesn't mean that there were 48,000 trademarks registered along the digital address with the same name. It can be that many domain names were registered with a name identical to the trademark that was registered many years ago and still in use. And if you're taking that into consideration, the conclusion is that similarity in names may cause quite a commotion on the market because overlapping names may confuse clients and website visitors, and as well, they can be used by bad actors who want to profit on somebody else's reputation. So this is the situation, the current scene. And since, in conclusion, since registrations of trademarks are increasing every year and registration of domain names as well, as people simply need to go online, so they need to get domain names. So unavoidably then, there will be more and more domain names and trademarks that are similar or simply even identical in name to each other, yeah? And in such a situation, we can imagine, let's say, two basic scenarios. Number one, we have the website address without a European trademark. And then in such a case, investing into a website positioning, which is indeed the positioning of digital address, or in building reach may prove problematic if one day we found out that some other company owns a trademark with the same name as our domain name. It may simply turn out that our type of business overlaps with what trademark is about, what trademark is protecting. And while we are quietly developing our business, we simply don't know about it, and we learn about it one day when some IP, so intellectual property attorneys, are knocking at our door. And if, in addition, it turns out that the trademark was granted earlier than we registered our website, we have a good chance to fall short and just that the domain name will be taken away from us, the one we are investing into reach, building up habits of our clients, visiting the website, etc. So it brings us to some troubles at this point. And another scenario, maybe, that we have a trademark, we are fine, we are safe, but without a website address. I mean, the one identical to our trademark name, which may happen easily because in the past we were registering a trademark, but we were not really thinking about the website, about getting the very same website with the very same name as our trademark name, right? Because in the past, it was not so obvious to have one together with the other. And in practice, this means that someone can create a site with a name similar to our trademark and impersonate our reputation, taking advantage of customer confusion. It could also happen that the site is is used for phishing, and our reputation suffers because we may be associated with some fraud activities. And it may also happen that a domain name with a similar name is registered by a domainer or cyber squatters. Domainers and cyber squatters are just getting domain names to trade them for profit. And such a domain name can be showcased at the domain name auction, for example. And then we might be simply forced to buy it back for an exorbitant price in view of the dangers and complications we may encounter, our clients and prospects may encounter visiting a website impersonating our identity. Yeah, so this is like a complex issue, and for that reason, URIT and EU IPO decided to start a cooperation with a view to ease life of both trademark holders and applicants and domain name holders. And it's currently already 8 years since we interconnected some of our pages and search engines. And namely, we integrated, let's see, the domain name search engine. It's so-called Whois search of URIT, so it's on our side. And then with a trademark search engine, eSearch Plus, it's called, of UIPO. And here you can see the Whois page, the Whois search page of URIT, where you can see the ebn.eu name, because this is what I did. I simply introduced the ebn.eu into the search window and the Whois search. And basically, maybe let's just say or explain to ourselves what is Whois search. So basically, every registry runs the Whois database, where the registration data of domain name holders are stored. And this is because a domain name as such is not viewed as a regular commodity. It belongs to so-called strategic or critical infrastructure. And for this reason, nobody can get a domain name incognito, as if buying a box of shoes or a t-shirt. Registration data of each registrant must be stored in the database. And in general, each registry is supposed to maintain such a database. We are for .eu, there will be a registry for .com, there will be national registry for .be, .de. Those all registries are keeping Whois database. They are supposed to be obliged by law. And then Whois search, we are seeing here the page of, it's an engine and it reveals some basic registration data and can be used by anybody because it's public. For example, you may check with Whois search if a domain name is still available for registration and if registered, by whom. And public version of Whois search reveals only part of information gathered in Whois database. Here you see that I type in ebn.eu. And because I type it in, it takes me to another page, another section of Whois search, and you can see here more information. Namely, first of all, you can see registrant. Registrant is simply, in professional jargon, the term for domain name holder. Domain name holder registers a domain name. That's why it's called simply a registrant. Yeah. Yeah. And for example, you can also see here just the language. This is the preferred language of communication. And then you can see who is the registrant. And this is here organization called EBN. And also you are here presented with the email you can use if you want to contact a registrant. There's also a very general information about the address that the EBN is coming from Brussels, Belgium. Yeah, and that's it, not more information. And on the right here, you can see the logo of UIPO. Yeah. And when you click on the link it will take you to UIPO site. Here in this green square, you can see the information that EBN is not available as a European trademark. And this is probably because EBN organization has a trademark with the name EBN. And when you click on the link here, European trademark, it will take you to EU IPO site, and you can actually check whether this trademark belongs to EBN or some other organization. Also, you can be navigated from that site to that site with trademark applications. And here you can see a registration data and who is search for a different domain name holder. It's of domain name oleg.eu. And the only information provided in here is just the language of communication, German, and email address. And this is because it's a private domain name holder, not a company. And in such a case, and due to GDPR and privacy policy, only very limited information is provided. So basically, you just have an email address and the language in which you can communicate with a domain name holder. And on the right, in this green square, you can, with the EU IPO logo, you can have the information that Oleg is available as a European trademark. It means it was not registered. And when you click on the link, it will take you to EU IPO site with the eSearch Plus search engine. And there you can search for trademarks. And this is also simply because UIT and EU IPO made their sites interconnected. So cross-checking is quick and easy for visitors of both websites, of both trademark holders, applicants, and .eu domain name users. And here you may see more examples of our cooperation. Namely, you will see 2 screenshots from the EU IPO site. The first one shows the European trademark applicants page, where the applicant is being advised here to check availability of .eu name at URIT's page. You can simply click here and you'll be taken away to the whois search of URIT. In order to register or check first and then register a name identical with a trademark before somebody else would do it. And that's quite important because cyber squatters are active and they are checking who is placing application for a trademark, and they tried to register a domain name area that a trademark future holder. Yeah? And another screen shows information displayed on EU IPO website for trademark holders already, because as of 2019, holders and applicants of European trademark can opt in to receive alerts as soon as a .eu domain name is registered. That is identical in name. Identical in name with a trademark name. And why is that so important? Because brand building and providing online safety for your company brand, it's like never-ending project in progress. And just so maybe at this point, let's sum up and picture that. In case a company has a trademark but doesn't go online, then somebody else can register a domain name which resembles the company's trademark name. And that might cost the company in question a lot of money and put their brand at risk. As very often, if somebody registers a similar domain name to somebody else's brand and trademark, that is to counterfeit the company's identity and products. And another scenario may be that you plan to register, you are smart, you plan to register a domain name next to your trademark, but you are not quick enough. And then somebody else does it earlier and now offers a domain name similar to your trademark or identical to your trademark on domain name auction. And that again may cost the company a lot of money because nobody should allow such a name, which is identical or very much similar to your brand and trademark, to just freely floating on the market, as somebody else may register it to get a website and then try to exploit on your brand this way. Yeah. And here I will speak a little bit shortly about another brand protection tool that is not connected to trademarks nor EU IPO cooperation. However, it's easy to use and it's quite or might be quite useful for you. In general, we provide for .eu domain name holders many other brand protection tools. Just for the sake of this short presentation, I'm not going to present them, but I would just mention that this is like, for example, DNSSEC protocol, which protects against unintended fraudulent redirections. And for example, I just checked ebn.eu site is protected with this brand protection tool. Then we are offering registry log, DNS score, and some other brand protection tools. But here I will just shortly focus or present on list of so-called similar domain names. And here you can see again the Whois page. And another part of which page I was showing before, it is the section with similar domain names. And you can see that you are presented here with the list of names which are sharing a visual resemblance to .ebn.eu. And that enables, that works, of course, for any other holder as well. So that enables such a holder to keep track of the names in question. Holders may check what the similar domain name are used for, right? And see if there is no abusive activity involved. And the holder may request, here with a blue button, to have a full list of similar domain names sent regularly to his or her email box on weekly basis. And this simply grants holders with knowledge which may shorten the reaction and attention time. So the sooner a company learns about existence of a similar website, let's say copying their own website or offering very similar products, the better chance to take proper measures. And as you can see, you may choose more extensions, not only .eu. So we are offering a list of similar names also for .com and other extensions. So this way you can have a complex overview of the situation on the market with names which are resembling visually similarity with your domain name. And now we are coming to the very last topic, which is domain name disputes. So basically, when a domain name you would like to register is already taken by somebody else, you cannot do much about that. You just may try to contact the current holder to check if he likes to trade the domain name back to you. You can use for this the email address which you find in the Whois search. However, in life there are more stressful situations than that. And this is when you realize, for example, that the company name, your company name, is used in some domain name address, and the website on which this domain name address is set simply keeps offering the very similar products to your products, or even your own products. You didn't know about it. It may also happen that you realize that your family name is used for some website, for the address of the website, for example, offering port sites for services. And this sounds like taken to the extreme, but I must assure you that we had like 2 years ago, there was a wave of calls from very nervous school headmaster calling us and asking us to turn down the website, which were using exactly the name of the school for the services in question. Yeah, and it makes sense because you produce this way a very organic traffic, because there are parents, teachers, students. They don't remember exactly the name of the website, so they browse it over the internet. They type in the name of the school, and voila, they get the direct link to the site in question, right? So whenever the situation gets really inconvenient for you, probably you need to go to the court, inform the police, but that takes time, that takes money and lawyers. So EURID is offering for .eu domain names 2 arbitration courts, one located in Prague, Czech arbitration court, and another, you know very well, WIPO in Geneva. And you can use their services when you want to defend your rights which are somehow infringed. You cannot go with any case and under any condition to such an arbitration court. You can do it when you have or you believe you have a prior right to the domain name, to the domain name somebody else registered. Yeah. For example, you hold a trademark, trade name, company name, family name is called very similar to the name of the domain name, etc. And at the same time, you believe that the current holder has registered or is using the domain name for speculative or abusive purposes. In such a case, you can challenge the registration. I'm saying challenge the registration because at the end of the day, everything what you did is just to make sure that the website will be turned down, that that it's not going to work anymore. So this is what you're receiving within the arbitration court. So you can challenge the registration via so-called alternative dispute resolution, which is ADR, the abbreviation, instead of going to a regular court. And also, if you are, for example, a trademark holder, you can also request the ADR court to transfer the domain name to you, and that you can use it then directly. And what we can say is that that the verdicts made by ADR are as binding as the one issued by a classical court. Also, that ADR procedure is convenient as it can be initiated without an assistance of a legal representative. It's also conducted online and by email, so you don't have to travel. There's no need for that. And the case is resolved by independent panelists. They are usually intellectual property rights experts, not judges. These are not judges. And disputes are usually held in the language of the domain name holder, indicated at the who is search, which is also might be also convenient. Probably you don't have to run the dispute in Hungarian or in Polish. And the average resolution time for ADR cases are 3 up to 4 months. So it's a very short period. And we may conclude that overall, ADR procedure represents a more financially viable option than a regular court proceeding, as it takes, we subsidizing both courts. So it takes just €100 fee per one domain and per one panelist. You can have up to 3 panelists. So if you are going wild and you are taking 3 panelists, it costs you all together €300. And within 3 up to 4 months, it's done. You have the decision and you know where you are standing. So this was my last input. I just touched on the issue. I didn't really had a chance within that short presentation window to develop more on the subject. But I hope that just the basic information I'm providing you now is just enough to start thinking about it and be more cautious when getting a trademark, on thinking about getting a domain name, which is part of your online identity and should be protected properly. Absolutely. Thank you very much.
Annette, no, thank you. Insightful, short and concise. Again, thank you very much. Perhaps we still, I know we're running a bit late of the original schedule yet. Flexible as we are, we can move things around a bit and maybe do some of the questions already here, and then we cut a bit short at the end of the training. I did see a question by Christina, and I do think Mary already provided quite a substantive answer, but maybe worth asking you to provide your 2 cents there too. Question by Christina: when I have a registered trademark and somebody creates a domain with this trademark, why isn't it an infringement of my trademark? So maybe feel free, Christina, to elaborate if I
yeah, maybe.
Oh, no.
Website online domain, you have rules of registration. Trademarks are for a different purpose. They help customers identify your business. They are separately registered. If you think about it, you will probably also register your domain. Okay, but what's the question? I'm still, maybe you could maybe Christina could a little bit elaborate on the question, if I may ask.
Yes, hi.
Yeah, yes, please.
Christina. I was asking this question because in the beginning of your presentation, you had these numbers and cases. For example, I have a trademark, but someone other has a domain name on this, and so this question arises. But I think you elaborated it a little bit more in the end. But is it an infringement or not, or is it case by case? So, for example, I have a trademark and I see someone other is using it for.
Yes. Maybe I'll just interrupt you. So at the very last slide, it was shown that you can you can dispute the registration of some domain name, providing you can also, it's not enough that somebody else registered a domain name. It's not enough, but in case you prove that the registration was done for some abusive reasons or in bad faith, then that's the reason for you to go and show, hey, I have a trademark. It's just the registration was abusive, not in good faith. So I want this domain name to be turned down, and I want this domain to be transferred on my behalf.
Yeah. Okay. Thanks. This was.
Yeah. So basically, whenever you have a trademark, it puts you in a good position, negotiation position. But it's not that you can just browse for any websites with the name which are very much similar or identical to your trademark and say, I don't like it, I want to stop them functioning. It's not enough. You just need to prove that they are abusive, that they are using it for some abusive activities, or either, sometimes they can impersonate your own identity. Sometimes they are just running some website which somehow harms or fires back to your reputation. So you can show it, you can prove it, and then you have good grounds to get this domain name from the holder.
Okay.
Thanks.
Answers your question, Christina?
Yes.
Perfect.
Thank you.
Thank you, Christina.
We're getting ready for Mary's intervention. IP scan. I think while you get ready and set, Mary, there's a question by Nahel, and I'll just throw it in here because I think it's going a bit in between and overarching of the whole topic, but it's an interesting question though. So for anybody who likes to jump on it as an expert or has experience in this, how to brand and trademark evaluation. So more indeed, is there a tool or you can monetize brand and trademark valuation, or offer it as a service to your clients, for example?
I can jump in a little bit on that one.
I would say it depends on your business model,
Yeah, I'll actually talk a little bit about that in the course of my presentation. So hopefully I might be able to answer. It's a very complicated area though, and not one you can just kind of click your fingers and value a brand, but there are different ways to do it. So yeah, thank you guys. Hopefully everyone can see my slides all right. Awesome, great. And what I might do during the course of the presentation, depending on timing, we might be able to nip out and do some actual quick searches so that you can see some of the tools in real life. So I'm going to really try and fly along through this presentation because I'd love to hear your voices. Great hearing some real questions getting asked. So, and the questions really are indicative of exactly what the IP scan is all about. So, and I'm here to really, I suppose, recommend it as an option for people who have the kind of questions that are being asked here today. What is the right for what purpose? Why do I need it? How do I get it? What are the limitations of the different kinds of rights, or how can I use them together in combination? And I think Aneta's presentation really showed us how interconnected and how congruent your IP strategy needs to be in order to really, I suppose, provide a very effective level of of protection to your business, so that all of your different efforts and investments are thoroughly protected and can actually be enforced in a robust, thought out, strategic way, which Philip talked about. And I think Philip has given us a brilliant take home in terms of his comments about the IP strategy can be a dead end or it can be a fast track. And it really is at the end of the day about creating value. So I think if we look now at the IP scan and how that might help you to get on the right track for a fast track rather than on a dead end or on a hiding to nothing. So I suppose the IP scan is an opportunity for businesses to take stock of where they are and to obtain very tailored advice as to what their next steps might be. And I also think it's a really good opportunity for people to ask exactly the kind of questions people are asking today, and to have an expert on hand who can talk through and discuss and teach and show you. So in many ways, I would describe the IP scan as, instead of handing a man a fish as a lawyer, it's a way of teaching a man to fish. It's a way of teaching businesses to mind and manage their own intellectual property better and in a very holistic way. So it's a really condensed way of getting the most relevant, most tailored information for where you are right now. There are limits to what the IP scan can achieve, but I'll touch basically on those. And I'm going to give you guys a whistle-stop tour of the application process and what to expect from an IP scan, so that if you or the clients that you are working with want to avail of this, that you know exactly what they will need to do. And finally, I'd love, as I said, to very briefly show you some of those searching tools and give you a little insight into what the IP scan can turn up and how you can maybe share some of these ideas even with you know, the entrepreneurs and the SMEs and the startups and scale-ups that you're working with. So I'm going to try and literally go through this quite quickly, and obviously I'd be delighted if there's questions as we go. So this slide really, I suppose, is a snapshot of a business at any given moment in time. So the dotted line kind of represents the semi-permeable membrane that is your company. And inside it are the different ideas that create the value for you and your consumers, your customers. So some of these are kind of crystallized intellectual property rights, like having a trademark that is registered, having a domain name that is suitably registered, having maybe a patent in place if you have invented a new form of technology or a solution. Maybe having a design. We talked a little bit earlier on about design. So if the shape or features of your product are what gives it its value, you might wish to register a design. So some of these are quite concrete and registrable. Other IP rights, as you know, just arise automatically, like copyright. And there are very few businesses that don't have some of these. So even businesses that would say, well, I don't have any IP rights, actually they probably do. And one of the interesting things about the IP scan is that people might not know what they already have, and they might not realize how, you know, valuable some of it might be. So we have a kind of a look at the company and really try and understand the company context. So they're very practical questions. And I guess because I sort of run as an operations manager as well as an EU trademark agent, I really like to get into the nuts and bolts of how the company runs and understand operationally and strategically, where does the IP fit in? So we would talk about, you know, what's your product or what's your service and what's your market? We would ask questions like, you know, what's the sales force? How are they acting? Are they selling this? What are the features or the benefits of the different things that you're selling? What is the legal expertise within the company itself? How much do you already know about IP or commercial contracts or different aspects that have brought you to the stage of wanting an IP scan? And then we have a look at the actual processes and procedures that are present in the company, so we can really get a good picture of how this works. So we look at the registered IP rights, and we look at the, say, for example, copyright or maybe databases or customer lists and stuff like that that exist in the company. All of those might be valuable information, commercial information that is sensitive. We do look for things like whether or not there are non-disclosure agreements in place, whether or not there are contracts in place with suppliers that protect the intellectual property of the company and so on. And then we look as well at some of the really soft IP. So soft IP, I guess, I always think IP is interesting because, you know, there's a lot of it that's sort of semi-fluid. It's not crystallized into a trademark or crystallized into a patent document. it's loose and fluid inside the organization, but it's still really valuable. So the knowledge, the skills, the know-how of your workforce, some of the business information that you gather just by doing your day's work, that's all, technically speaking, valuable information as well. So we have a look at that. And for me, I think a really interesting thing is getting the business owner to reflect on the information that passes in and out of that semi-permeable membrane that you have in your company. So everybody who comes to work every day brings inspiration. They bring thoughts, they bring ideas, they see new stuff outside in the world. So there's constant flow of information in and out of all of these companies. Some of it is public domain and it's not protected. I think it's really useful to sometimes talk to people about the concept of what is the public domain? What does it mean for an idea to be in the public domain? Because we can't literally protect everything. There are lots of things we can't protect, and knowing and being able to make a sensible decision about what's really valuable and protectable versus what's actually out there in the public domain, and we really can't try to own it. And then looking at third-party rights. So in my diagram here, I've got two sets of arrows. I've got green arrows, which are third-party rights that we really want to have and are flowing correctly. So for example, if we're licensing in technology from other people or reselling products that belong to other people or whatever, we might have licenses in place, we might have agreements in place, and the third-party rights are being used correctly. And that can be as simple as the imagery on your website as to whether or not you actually have, if you're using stock imagery, have you licensed that correctly, or could you potentially be infringing on somebody else? So we're looking at that to see that all of those third-party rights that are used correctly and are used in a safe way. And then what we look at maybe is if we identify any areas of risk. So this is, like we talked about earlier on, there was lots of great commentary there from Anita and Philip about really, what happens when things go wrong. As much as that can happen accidentally, it's still a problem and still needs to be dealt with. So, what happens if somebody else is actually infringing purposefully or accidentally on your rights? What happens if a competitor starts to produce something that is too close to yours for comfort, or that starts to create consumer confusion in your marketplace? So we look at these areas of risk. And this helps us build up a picture or a snapshot of what's going on in the company right now. How high is the level of awareness about these different issues? How high is the level of understanding of the commercial risks? And how much are the company exploiting their own IP for best effect? And this is where the valuation of IP comes in as well. There might be questions there about, so what's really valuable and why? So it's very practical. The IP scan is absolutely one of the most practical, I suppose, exercises that I think an IP attorney can perform. And it's really enjoyable because you're getting to know the business really well. And I quite enjoy it because you sit down with the business owner or with their top team and spend some time really getting to know and understand their business. So this is me actually doing an IP audit. This is doing an IP scan type meeting. We sit down around a table. So the SME gets involved from the very get-go. They complete a self-assessment tool in advance of a visit. So they tell me a bit about their company. I go off and I do some homework and some research about the company. And I will then come back to them and say, look, I've had a look at your website, I've had a look at your products, I've had a look at your competitors. You've told me a lot about what you do. We have a useful, friendly chat. There might be some follow-up actions that I would recommend, and that's really tailored. Every single IP scan I do is different. And that's because I have to meet each company exactly where they are and see what they want to achieve and try and lay out the steps that would best help them in my professional opinion. So it's not as such legal advice, it's suggestions, it's a discussion, it's a very fluid conversation. I'll issue a report that is cross-checked for quality by the Intellectual Property Office in Ireland, where I work. And then the SME can claim back up to 90% of the cost of the audit itself, of the actual IP scan. So they get their report, they pay me, and they are reimbursed up to 90% of the value of that. And it's up to the SME then as to whether they want to implement some of the recommendations, none of the recommendations, all of the recommendations, and to perhaps successively reiterate the same type of process for themselves. So like I said, it's like teaching a man to fish. I really enjoy the fact that they can go through this cycle themselves of having a sit down. And that's, I suppose, one of the great strengths of the IP scan is that it encourages businesses to see how to sit down and look at their IP strategy and really think, is it fit for purpose or has it changed since the last time we sat around a table and discussed all of this? So it's a really simple process. Some of the key benefits, I think, small businesses, startups can be quite concerned about the cost of legal services. I think that's a big fear factor for them. And I think the fact that this is a great program because it takes away the fear of how much am I going to pay for things and can I afford it? Really, the certainty is as important as the grant itself. Many recommendations are, free or involve very little cost, and it's a very easy process to follow the recommendations that I would lay out. I always try and meet the company where they are in terms of budget and so on as well. And like I said, it's an iterative process for them. We're not expecting them to go out and file 200 trademarks in the immediate aftermath of doing an IP scan. It's really important that this actually works on a practical basis for the client that we're serving, and it's an opportunity for them to reiterate this process over and over. I don't want to dwell too much on this because it's all available on the EU Ideas Power for Business site. But like I say, the IP scan is covered very well, up to 90% of the costs are reimbursed. And it leads on very well to the second voucher under the SME fund, which provides reimbursements for EU trademark and design application fees, and also national or regional trademark, if you're say in the Benelux or whatever. So there's lots of different ways for the companies who come on the IP scan to go forward and implement some of the recommendations at a very low cost. So what it is and isn't, again, very straightforward, really. I guess I'll labour here more what it isn't so that people don't get confused. It's not an equivalent of a lawyer's billable time. I won't be doing, say, trademark clearance searching. I won't be sitting down saying, now I'm going to just perform standard trademark attorney tasks and hand you back a single clearance search, or hand you back a patent search, or hand you back a draft of your IP contracts. Those are kind of separate standalone exercises. They would actually be implementing the recommendations of the type of report that we would come out with. So it may be the case that some of those things need to be done separately afterwards. But the idea behind the SMEs IP scan really is to suggest the best practices and to allow the SME to go forward themselves with those in their own time and choosing whatever provider they wish in order to help them with that. So it's just important that people really understand what it isn't as well. It's not legally binding advice. There's no obligation on people to have to agree with your experts' recommendations, but hopefully they will be eye-opening and hopefully they will be helpful. So some of the real life examples that just, the type of questions that these IP scans tend to throw up, questions like who's actually the legal owner. Sometimes, when a business is starting up, people will register rights in their own personal name and they forget then over time to have the housekeeping in order. And sometimes businesses change structure as well. So, what starts as a company with a limited by guarantee might end up as a PLC or a company that's, in a different structure, a limited company or whatever. So we have to look at whether or not the housekeeping of the register needs to be looked at, and if really the entity who has registered the IP is also the entity that's using the IP, because it can happen that sometimes they're not the same and they need to be tidied up. I guess it's great because there's a lot of support. So if it does throw up questions and queries, as say, we can be there to answer them at the time. So what if there is potential infringement on either side of the table? What will we do about that? What are our options? So again, these are all very unique situations that we have to meet each of the IP scan companies where they are and try and provide them with advice. But these are the type of typical questions that might come up in the course of the audit, and we might be able to provide some help or some support on that. So I think it's quite useful, and I think in terms of helping the SME to define its own strategy, that Philip talked about, the awareness, the detecting of infringements, risk management, licensing, and just good admin and housekeeping. All of these are the types of topics that kind of really crop up and can be addressed. And so I think that's probably all rather of handy to be able to sort of look at some of the practical questions. Like I said, very much what's coming up here today in discussion. Now, I'm not going to labor this, I know we're short on time, but essentially this is just to show you how easy it is. This is an IP scan request I filed earlier this very week. And essentially, you just fill in very straightforward details about the company. When you're logged in, you need to log into the EU IPO, and you can do that. You can set yourself up an account if you don't already have one. It's really easy, it takes about 3 minutes. Because I'm filling in the form, I need to upload a declaration, which is just basically confirming from the SME that I am in fact representing them and I'm doing this on their behalf. So if you are doing this on behalf of a company, you need to upload a declaration on Honor, otherwise they do it for themselves. And then you'll find that the company has been set up within the SME fund application tool. It's really easy to do. And then as soon as you've set it up in the My SME box, then you go into your SME fund application and start a new application request. And again, it's so easy. There's literally a drop down. So the company you've created will appear immediately under the company name. You select it from the drop down. So if, like me, you have several companies that you're working with, you choose the right company you want to apply for. You literally just tick the box of the voucher that you want to apply for. In this case, you might apply for both. And then you'll get a notification. So it's really that easy, guys. You can do it in about 3 minutes. A submission is confirmed right away. And then within a few days, I know technically the evaluations, they say on the website, it'll take about 15 days. In my experience, it's a lot quicker than that. Normally, people will come back to you very rapidly to say that your application has been successful. And then you can go ahead. So the company then can go on and apply to their National Intellectual Property Office for an IP scan service. And then within a couple of days or a couple of weeks, depending on the company's own time frame mostly, we set up that process, getting the pre-meeting assessment tool filled in by the company. We do our homework on the company, and then we'll arrange a meeting that maybe will take an hour and a half, 2 hours. I usually like to break them up because I find it easier to do 2 shorter meetings because people need time to think between them. But I guess really the idea of it is you have a meet, you have a sit down with the company, and then you produce the report for them about where they are at. So it's really simple. That's what you would expect. What would you see as the outcomes? Well, like I said, we've discussed sort of what we look at. I've discussed what we try to identify for them. And really we come out with these recommendations then saying, look, you have these things, you are missing these other things. Maybe some of these are very practical outcomes, like it would be a good idea to maintain a clearer indexed register of all of the different materials you create if copyright is important to you. Or let's have a look at what's your IP assets that you have, and have we an IP register of all of the different assets that you have? So for a company I did one for recently, they had a trademark and they had just allowed it to expire. And so one of the things that we recommended was that they would try to rescue it while it was still in the grace period. So we managed to save their trademark, which was literally just after expiring. So we got it reinstated on the register because it was an omission. It was a straightforward omission and it was quite recent, and we were able to pull that back. So it just helps people keep on top really of best practice within their organization. So there could be lots of different things. You'll see this slide when you get the slides out. These are the types of actions and recommendations we might look at. So it touches on all kinds of very practical things for SMEs. We don't just sit there and talk about IP. We really talk about, for example, how are you going to finance your IP rights? How are you going to enforce them? What budget are you going to need? How are you going to implement this in terms of your marketing and branding strategy going forward? So again, the speakers this morning have already talked a lot about these, so I won't labor them, but I think it's really interesting that the IP scan brings it all together as such. And what I'd love to do, if we have a moment, and Bram, interrupt me because I know we could be too short on time, but what I'd love to just show you for 1 second is just to see sort of the whole screen here for a second. So hopefully I will be able to get out of that show. and be able to show you my screen, because there are one or two tools. I know we don't have a lot of time, but the first one I'm going to show you is literally Google. I would love if every inventor and every SME were to actually Google their own trademarks or their own, I suppose, IP rights that they're interested in having. I think that would be really, really helpful, because they just don't do it before they call us. And I find that kind of amazing. You wouldn't even do an internet search on yourself. A second tool I'd love to show you guys extremely briefly is TMView. So we talked a little bit earlier, and people have said, I'll show you the trademark register and how to search it. It's so easy. It really is. So if you go to trademark, the TMView site, tmdn.org, or you can just Google it, and it'll pop up, and you can put in the trademark name that you're interested in. So I thought, since tomorrow is St. Patrick's Day, we could have a look for Guinness. And you can literally type in the word you're looking for, and it will bring back a whole rake of results. And then you can hone down on these a bit more using the filters on the side if you wish. So if I said, okay, I want to see those that are registered in Ireland, and I want to see those trademarks that are currently registered, or maybe new applications that have been filed. And so I can literally click on the apply button, and it will filter down and show me the registered trademarks. So here we go. You can see the original date of the filing of the trademark for Guinness. Long predates the existence of the Irish Republic, by the way, back in 1889. And that's how Guinness have the symbol of the harp, as it would normally be thought of as a symbol of Ireland. So how did Guinness manage to get this? Well, because literally they applied for the trademark before the state was even formed. And that's why the Irish state used the harp in a backwards position on our government things. It's kind of interesting, isn't it? So that's literally a very, very quick, I'd love to show you more, but it's just the quickest of introductions, but you'll soon figure out how to do the searching, the more sophisticated searching. The other tool I'd love to show you is Design View. This is again through the same site, and it'll help you search all of the designs. So if you want to find something, you can literally go in and type what it is you want to find, like, you know, glass or bottle or whatever. And what's really interesting, I'll just show you the advanced search on this one. It works exactly the same way as TMView, so you can use the advanced search for both. So if I said, okay, I'd like to find all of the designs that have been filed by my company, and let's say I want to find all of them that are currently registered, and I'd like to find all of them that are registered at the EU IPO, and I say, okay, fine, let's search. So it will show us, shall we say, the live or current registered designs that are registered. And again, you see that you have the filter button here. So if I wanted to only see clothing garments, if I only wanted to see most recently applied for application date within a particular time, if I want to see, you know, by a particular owner, so I can have a scroll and I can find I'd like just particular owner, and so on. So it's really great because you can actually very quickly sort of narrow down and find the design that you're looking for. So I wish we had more time, but on this occasion we don't. Finally, I want to show you Aspasnet. Aspasnet is a patent search tool. I'm not a patent attorney, so I'm not going to claim to be able to explain all the ins and outs of patents to you. But if you do want to see what's out there, so let's say, for example,
Mary,
yeah.
I unfortunately have to interrupt you here and then cut you short and move to the next speaker.
Yeah, no, we're very tight on time. So
indeed,
that's the last one that I really
late.
wanted to show people anyway, is just to show you the 3 tools and let people figure out how to use them after. Thank you so much, guys, for the opportunity of speaking about the IP scan. I hope it will be helpful for you and for the different SMEs in your different countries.
Absolutely. Thank you so much, Mary. That was elaborate. Gave us a lot of hands-on tools. I think for now, indeed, linking IP scan to the EU IPO SME fund. I would like to give the word to Elisabeth. Tell us a bit more about what EU IPO has for entrepreneurs in store for funding. Thank you once again, Mary. And the floor is yours.
Good morning or good afternoon, to everyone. I am Elizabeth Karayabi. I'm from EU IPO, and Mary actually gave me a very nice introduction about the SME Fund. So today we will talk about something different from what we heard this morning. So this year, 2023, is the third consecutive year the European Commission in EU IPO, with the support of the industrial property offices of the member states, that are launching the SME Fund initiative, which addresses the need to make the intellectual property services, the one that the previous speaker presented, more accessible to small, medium enterprises, and of course to support their competitiveness through better use and protection for their IP. So intellectual property refers, as the previous speaker said, to creations of the human intellect, such as artistic works, designs, symbols, naming, images used in commerce. So as we have heard before, when we speak about intellectual property, inter alia, we refer to trademarks, designs, patents, utility models, plant varieties, geographical indications, copyrights, trade secrets, domain names, of course, and also company names. So there are strong links between growth and competitiveness of the SMEs, and of course, on their use of their IP. All of them are valuable assets of any company, and it's critical to know how to protect them. However, the SMEs, as Mary said, often lack time, resources, knowledge to address the IP issues. Our initiative as EU IPO and SME Fund, we offer financial support to the European SMEs to protect intellectual property and to guide them to develop an IP strategy. With this initiative, we have made a success until this 2021. More than 40,000 SMEs have applied for the SME Fund and benefited from more services to protect the IP rights. Important to say here that more than 3/4 of these SMEs were totally new to the IP rights. SMEs also represent the 99% of the business in Europe and 2/3 of the Europe employment. Therefore, supporting them, it is critical for the economic recovery. So that's why we designed this. These are the new elements that you see in the slide, in the second slide. This year, the overall budget allocated for the voucher 1 and 2 is 25 million. It started on the 23rd of January, and it will be open until the 8th of December, or until the funds are exhausted. We have also made a lot of improvements to be more successful, and also to suit to the needs of the SMEs. Not only we created a simpler and faster and more flexible process, but also we have improved the financial support. We increased the number of the fees and also the IP services. There are two phases, okay? The first phase, the financial support that is provided now, it is only on trademarks and design at national, European, and international level, as well as the IP scan, a service that, as Mary explained, provides advice on the IP strategy. Then in a later stage, the financial support will be offered for patent protection, national, European, and international level, and also for community plant variety. So that's why please stay tuned with our webpage to see when the second stage will be released. If we move forward in the next slide, we will see which companies they are considered small, medium enterprises. I will go very quickly through that. If it is medium size enterprises, that means that they have to have less than 250 employees, and also an annual turnover less than 50 million. In case of the small, employees fewer than 50, and not to exceed the 10 million. And the micros, they have to have less than 10 persons and don't exceed the 2 million. So if the company belongs on one of these categories, is an SME and can apply for the SME Fund. So if we move forward, we will see how it works. So first of all, the SME or you have to apply for the grant, and you will receive an answer in less than 15 days. Then you have 2 months, extendable to 4 months, to initiate the initiatives. When we say initiate initiatives, activities, we mean that you have to apply for trademark design or ask for IP scan. Okay, and request it. You must apply at least for one activity, request the reimbursement, and within this period, you ask for the reimbursement. If you don't ask for an extension, or if you don't do that in the period of these 2 or 4 months, then your voucher will be expired. Once you initiate, you applied and you paid, starts the implementation period. This is 6 months for all activities, IP scan, trademarks and design application. And in order to initiate more activities and more reimbursement, the reimbursement will come to you in 30 days. Let's see now which fees are included in each voucher with more details. So if we move forward, one of the objectives of the multi-annual SME Fund initiative is to allow the SIM to evolve. Okay, so from the lessons learned that we have the previous 2 years of the implementation and interaction with all the stakeholders, the SMEs, the European Commission, the member states, IP professional experts, help us to identify needs. So the SME, if you can move forward with the slide, the SME cover the fees for selected IP activities, and financial support is provided in the form of vouchers. Okay, so here you see the 2 vouchers. Since the 23rd of January, 2 vouchers are offered, covering IP scan, the pre-diagnostic services on one hand, and trademarks and designs on the other hand. So now we move to the next slide to see more details. Okay, so closer look to voucher 1. Voucher 1 is for IP scan. IP scan services, I will not go details because Mary presented very well. IP scan services, they aim to advise the SMEs on intellectual property rights, identifying the types of the IP assets that they are valuable and should be protected. Also, if there are already IP rights that they are already protected, this IP scan gives the opportunity to further exploit and gain additional benefits to support the businesses. Okay, so the IP scan services now are offered by experts appointed by the national offices, that they are in collaboration with the SME Fund. The IP scan under the SME Fund SIM must be established in EU member state where these eligible IP scan services can be provided. So if we go to the next slide, we will see which member states they offer the IP scan service. And you can see also the reimbursement rates per the offices, and it is 90% the reimbursement rate. So this cost is fixed by the member states. Let's move now to the next slide and voucher 2. Voucher 2 covers trademarks, designs at national, regional, EU and international level up to the amount of 1,000 euros. For trademarks and designs requested for national, regional and EU level, the reimbursement is 75%, and the fees that are covered are application, class examination, registration, publication, and deferment of the publication fees. For trademark and designs requested at international level, the reimbursement rate is 50%, and the fees that they are covered are basic designation and subsequent designation fees. Let's move now to the next slide. So to see that how SME Fund works. So there are 2 steps. First on, you fill in and you submit online the grant application form, and you request your vouchers. Then, after you receive the grant decision, that, as we said, it takes less than 15 days, you can request, apply, pay for your activities. You go to the national office, to EUIPO, to WIPO, and you apply for trademark designs, or you ask at the national office the IP scan service. Once you have paid for these activities, you log into the account you fill in, and you submit and you request the reimbursement. These are the 4 steps. Here, I have an example to show you how it works, the activation and the implementation period. Okay, so let's imagine that we have an SME that is awarded, have a look to the blue line above, both vouchers on the 1st of February. It has until the 1st of April, which is the end of the initial activation period of 2 months, to activate the vouchers by requesting a reimbursement. This is the way to activate. By the end of March, the SME is not ready to activate, so it decides to extend its voucher for another 2 months, which brings this, the end of the activation deadline, the 1st of June. So below we can see that the SME activated the vouchers by the end of May, just in time before the expiration, okay? And from that date starts the implementation period where the SME have additionally 6 months until the end of November to initiate other IP rights, to apply for another, for a trademark, design, or ask an IP scan. And of course, request the reimbursements. Let's go to the next slide, where we can see that when you receive the grant, that's the second step, within 15 days, we said that you can receive your grant. But maybe if the application is not correctly filled in, you receive an email with a clarification requesting details or missing information, or the document was not clear enough. Or you can receive a rejection email by stating that you are not, or the SME is not eligible to receive the grant. So next, now that we have explained the whole process, I want to give you some important information of the SME Fund 2023. Okay, so keep in mind that SME Fund 22 initiative is still ongoing, although the applications have been closed in December. Okay, so if an SME fund in 2022 has applied, maybe the vouchers are still valid. So they can continue with the reimbursement or with the application. So that means that this year, SME Fund 2022 edition and SME Fund 2023 edition will run in parallel for a period of time. Each SME can request 1 voucher per type of activity within the rules and the limits, of course, that we said before. In addition, if the SME has received a grant the previous years, 21, 22, they can also apply for 2023 grants. And what else this year? Yes, we have the fast track process in place, which means that if you have already applied in 2022 and you have received reimbursement, there is no need to send us again all the document. This is what we call fast track process, to speed up if you apply again this year. And then we have more activities, as we can see here in this slide. So we have highlighted the upper part with a red line because this is the vouchers that we have already launched. And with yellow color is the ones that will be available later, 3 and 4. Let's go and see a little bit in the next slide, the patent-related activities, because we believe that we are going to launch soon. So as in the previous year, this voucher will cover the same eligible fees for a national patents, filing, search, examination, grant, and application. The biggest change here is that we have introduced a new service, the patent prior art search. This service, again, is provided by the member states, but it's for a worldwide search. Prior art search is a key in helping the SMEs decide whether or not they go ahead or they request the IP right. And also the other service that we included is filing and search fees for European patents. The reimbursement is 75%, and this reimbursement is coming from the funds of the European Commission. The activation period in this case is the 2 + 2 months. That means 2 for the beginning and extendable to 4. Let's see now in the next slide Another new voucher that we have, voucher 4, and this is a totally new first time that we talk about the plant variety and plant variety fees that are covered under the SME fund. The total amount that is covered is 50% on the online application fee. The voucher has again 2 months activation period, extendable to 6 months this time. Why? Because the proof of filing from CPVO it's larger, it's bigger than the other organization. So we extend it to support the SMEs to 6 months. But in this case, we don't have implementation period because the online application cost is 450. We pay right away 50%, so there is no implementation period. The implementation period, or the aim of the implementation period, is to allow the SMEs to keep using their vouchers and requesting more reimbursement during the time. Again, the budget is covered by the European Commission contribution. So here I will go quickly because it was presented by Mary, but where to apply. So if you want to apply, you go to the SME landing page on the EU IPO webpage. Okay, I will put in the chat later the link. So in this flying right side menu, you can go to apply, and you are going to go directly to a SME fund user area. Okay, there, if you have already applied, so there's no need to create new credentials for 2023. Please use the credentials that you have. But if you haven't submitted before, you know, you have to create first your EU IPO account, and then you go to apply to the SME fund. So what you need is to register the account, the EU IPO, and then you go log in. Let's go to the next slide. Once you log in, you enter in the SME fund user area, and from this user area, you manage everything related to the SME fund. No application of trademarks or designs in EU IPO, only related to the fund. So from the creation of the profile, for the grant application itself, for the vouchers and for the reimbursement, everything is done here. Also, I have to mention that you have the possibility here to have the live chat platform to ask any support professional at every stage from our people for this process if you need. Okay, when you enter for the first time, you have to request to complete your user profile. Okay, by putting the contact person, the language communication, indicate the correct email, please the correct email, because everything will go and communicate it through this email. And when you finish, you click save. And then in the next slide, we can see the user area, my user area, where you create the company profile. As you can see here, I have 4 companies, okay, that I have created before. So if I want to apply for a new SME, I can start filing from here, create new SME. I have to put the address, the postal code, where it's based, very important, the tax identification number, upload this tax certificate is very important. And then you move forward with the contact details from your client. It is very important that if you are applying for a client, that we need the contact details for the client, the name and the last name, the email address, the mobile number, because when finally we give the grant will go directly to the SME, not to the representative, okay? If you are a representative, or if the SME fund has a representative, has to create or upload a declaration on honor. This has to be signed from both sides, and you can find in 2 places the declaration of honor, in the beginning of the website or during when you apply. Then you have to add the bank details, very important. Please double check that you put the correct bank details or the bank details of the SME, and also upload in PDF the bank certificate. Let's move now to the next slide. very important, please, before you move forward, please review the bank details, because the reimbursement will be paid directly to the SME bank account. And this is the most problematic area that we have when we check your applications. Then you click next, and then you have to choose the voucher. Now we can see that we have 2 vouchers, but later you will be able to see in your user area the 4 vouchers. So either you request voucher 1, voucher 2, or both, but each voucher can be requested once a year. And then you go next. So in the next slide, I'm showing you that the most important documents that you have to have when you apply are these 3. Okay, the BIC certificate, that must be an official document. If you are self-employed, you must submit a sole trader registration certificate in order to be clearly, and we can understand and identify a registration number, and you are the owner of the SME. Of course, as we said, the bank certificate, it has to be clean, it has to come from a statement from the bank, and it has to be the correct number, the IBAN number. So with these 2 documents, you are okay. But, however, if the company is using the services of an external third party, as we said, declaration of honor is important to be filled in and uploaded. So some tips in the next slides you can see before submitting. Please check the documents, check that they are readable. Sometimes, sounds silly, but it has to be readable, and also the contact emails that you have to provide. Please read the frequently asked questions that we have in the SME Fund landing page, use the online chat, and we are all here for you. So now in the chat, I will try to copy paste all the links that I was referring, and thank you. It was nice to be here.
Thank you so much, Elizabeth. Clear story. That wraps up effectively the training, but not before I think we have 2 questions that could be potentially interesting regarding the coverage of countries. Let me see, I saw it here. In the beginning of your presentation, there was a list with several countries. Some of them were not included, I see in the chat. Does that also mean that they don't offer IP scans?
Yes.
Specifically, France is one of the countries that was not in the list.
True. So maybe the national office, they offer the IP scan. I don't know. But what I'm referring is that the IP scan that is under the SME fund, okay, and they can be reimbursed. So this is the list. If it's not on the list, no, it cannot be reimbursed.
Okay, clear answer, perfect. I'll stop the slide share as well. I know we're running a bit late and looking at the cohort. Are there any pressing questions for the people in the room? Otherwise, I'll wrap up and invite you for the next session. Any questions? No. Wonderful. Well, we started this morning with the opening of Nicolas from EUIPO and Laura Leci, CEO of EBN, with the warm welcome. We went from Philip, just to recap, with the business strategy and the IP strategy, already touching on trademark filing and NDAs. Agneta unpacked this further and added a few components. Specifically, I found it quite interesting, the relationship with the trademarking and domain names. We dove a bit deeper with the contribution by Mary, touching into, okay, how do I get a holistic scan of my MP, basically of my company, and how does it relate to IP in the broadest sense? We've seen indeed, and I'm most likely familiar with it, IP is a broad topic. We dealt with trademarks mostly today, and copyright as well, domain names. And then we concluded with Elizabeth, and we're very grateful basically for the EUIPO SME fund that has also been run this year. So granting SMEs financial support to lock in your IP and be secure to go ahead. I think for next session, I would just like to highlight that we continue. Yes, we go a bit broader. We'll explore, among others, and I made a quick note in the chat as well while I was speaking, dive a bit deeper into IP exploration and discovery with speakers from the adjacent Possible Studio. Check them out. They're on the way and doing incredible, interesting things with IP. Forming new companies by combining IP, for example. And we dive a bit deeper in IP protection and enforcement. Of course, with EUIPO focusing mostly on trademarks and copyrights. And we have the World Intellectual Property Office as well with us to focus a bit more on patents, the more international and also outside of Europe. So on that note, I would like to give the final words to Laura, if she agrees, just to say goodbye and welcome you to the next session. Thank you for joining us. See you the 30th. Laura.
Thank you, Bram, and a big thank you to all the speakers, but also the audience. It was really, really nice to see such an engagement in terms of participation and in terms of following. So looking forward to seeing you all again the 30th of March. Thank you very much and have a great rest of the day. Goodbye.